The trouble with privacy in India is that we don't have an explicit fundamental right to privacy written into the Constitution. We've derived a fundamental right to privacy through a series of judgments. When the other case came up before the court, the Attorney General, while defending Aadhaar, he contended that we do not have a fundamental right to privacy. He based this argument on the fact that the two earliest judgments, MP Sharma and Kharak Singh, had been decided by benches which were larger than any subsequent bench and had never therefore been conclusively overruled. And so the Supreme Court decided to convene a 9-judge bench to conclude once and for all whether MP Sharma and Kharak Singh were good law. Puttaswamy judgment case categorically says that there is a fundamental right to privacy. They say it is a natural right. The right doesn't have to be written, but it exists. There were 6 opinions that were rendered. All 6 opinions concurred with each other. And in that, it is one of the most categoric affirmations of the concept of privacy in the history of Indian privacy jurisprudence. The judgment covered many aspects beyond just the fundamental right to privacy. As is true of all fundamental rights in India, no fundamental right is without a restriction. The judgment went on to prescribe a threefold test to determine when the state does restrict the fundamental right to privacy, whether in fact that restriction is tenable or not. And the threefold test essentially is this, that the state can only restrict someone's privacy under a law. That law must be in support of a state need, and that the actions that the state takes must be proportionate to the need. Judges had a difficult job in front of them. They wanted to declare in as unambiguous a manner that we have a fundamental right to privacy. But they recognize that we are in a remarkable stage in our technological development, where the benefits of technology can be significant, but at the same time, the ability of technology to do harm is immense. The court was unable to actually tread a path through these two different extremes and actually give us some direction in terms of what we should do in the future. But at the same time, it's a far-reaching judgment, and I would imagine that lawyers for many years to come will be able to pick up threads from the judgment and launch new attacks against the government using the strength of a very strong 9-judge opinion.